Hi, I'm Mike Stein, and I'm a trial lawyer in Los Angeles, and this is Mastering the Art of Trial Presentation. I'd like you to think of trial prep and presentation as a pyramid, and we're going to walk up the pyramid together. At the bottom are 3 blocks that I entitle the hook, organization, and the graders. In the lower left-hand corner, the anchor block is what I call the hook, otherwise known as the case theme. It is essential for you to be able to come up with some theme to describe the centerpiece of your case to the jury. The way to do it is to isolate the key event in the case and then use one descriptive sentence to describe what that thing is about. At the other end of the pyramid in the corner is what I call organization, otherwise known as the trial notebook. Pleadings, discovery, other types of information that you have to have at trial with one important rule, what I call the 10-second rule. You must be able to put your hands on anything the jury needs to see in 10 seconds or less, or they won't wait. Finally, the graders, otherwise known as voir dire or jury selection. We are one of the only professions that has the ability to pick the people that will decide how good a job we've done. Here are 5 things to suggest to you to what to say and what to ask in jury selection. Number 1, ask jurors if they think they're good at determining somebody's credibility, whether they're telling the truth. Ask some parents, what do you do when the kids at home bring you conflicting versions of how something happened? Believe me, they're already good jurors. Number 2, ask them, are you good at deliberating and defending a position? They're going to have to go into a room with 11 other strangers and discuss your case and your client's problems. Finding out whether they're going to be a leader or a follower is an important consideration. Number 3, for those who have had prior jury service, ask them if they had a good time. Did they find it to be a positive experience? If they didn't, I don't think you want them on your panel. Number 4, ask them, will you follow the law? Some jurors will look at you in the eye and say, yes, we will, and then strange things happen when they get back in the room. Make sure they'll follow the court's instructions. And finally, I always like to ask, would you pick you? You'd be amazed at what you hear when you ask that question. Here are 5 don'ts of jury selection. Number 1, don't look away. When someone's talking to you, look them in the eye. Number 2, don't mispronounce their name. Number 3, don't forget their name. Number 4, don't criticize their response. That's a great way to get somebody to like you. And number 5, don't lead. Don't ask, isn't it true style questions. You want the juror talking. That's the base of our pyramid. Next up, 2 blocks, what I call casting and storytelling. Casting is witness and exhibit selection. Here are 5 things to consider when deciding who you're going to call as a witness. Number 1, does the witness have something relevant to say? Number 2, do they have the foundation to say it, meaning do they have personal knowledge? Number 3, are they credible? Number 4, do they have some inherent bias that your opponent might be able to exploit on cross-examination? And finally, number 5, perhaps most importantly, are they available on the day of your trial? Here's 5 factors to consider when deciding which exhibits to select. Number 1, does the exhibit prove the element of a claim or defense? Number 2, does it provide the foundation for a witness's testimony? Number 3, are there any issues with its admissibility? Number 4, is it the type of document that opposing counsel might stipulate to be admissible? And number 5, is it presentable through some form of technology? That's critical in this day and age. Storytelling, opening statement, the single most important phase of the trial. Jurors are told, don't make up your mind, and they always do. This is your first chance to engage them. Here's 5 ways to do it. Number 1, tell a story. Do not tell them the evidence will show, just tell them what it will show. Number 2, eyeball them. Look them in the eye, connect with them, let them see that you mean what you say. Number 3, put them into the critical moment, the moment that caused the case theme to come about. Make them feel what your client felt. Number 4, argue without arguing. Active words, active verbs to show you mean what you say. And finally, number 5, tease them a little, but hold some of the information back. Translated, don't try your entire case in the opening statement. That takes us to the next block. I call it the show. It's witness examination. It's time to put on the show. Here's 5 things to do when preparing your own direct examination witness. Number 1, review all of their prior testimony, deposition, declarations, verifications to discovery. Number 2, review with them every single exhibit you're going to introduce into evidence while they're on the witness stand. Number 3, review your examination outline with them. Let them see where you're going to go during their examination. Number 4, witnesses ask me this all the time. Should I look at you? Should I look at the jury? I say yes. Sometimes they should be looking at you, sometimes they should look at the jury. Review with them when is appropriate. And finally, take them up to the courtroom. Let them see the setup and the procedure before they're sitting there for showtime. Don't let them find that out for the first time when it really counts. Here's 5 things to consider when actually presenting your direct examination case. Number 1, always begin and end with your best, strongest witness. Number 2, emphasize all of the pre-dispute behavior, meaning what was going on before your client hired you. Number 3, give your witness center stage. They're the star, not you. Number 4, don't lead. You're not allowed to on direct exam. What happened next, then what happened, that's the way to ask it, and that's the way to make them center stage. And finally, call your friendly witnesses before you call hostile witnesses. I like to show the other side's case after mine. Tell the jury why you're strong before you show them why your opponent is weak. 5 don'ts of cross-examination. Number 1, don't do it unless it's absolutely necessary. Forget TV, forget movies. Sometimes the most powerful cross-examination is the following: no questions, Your Honor. Think about that. Number 2, if you are going to cross-examine, don't repeat the entire direct examination. Pick your points, pick the strong things you need to cover, and then sit down. Number 3, don't use one tone or demeanor the entire time. That's boring. Modulate your voice, modulate your approach so the jury will follow you. Number 4, do not elicit sympathy for the witness. Even when you're scoring points, at some point the jury sees this as your home turf. They're going to start to feel sorry for the very witness you're trying to break down. Don't do it. 5th and finally, easier said than done, don't ask that one question too many. Yes, it's true. Don't ever ask a question you don't already know the answer to. A whole case could be lost if you do. Finally, appropriately top of our pyramid, the finale, closing argument. 5 things, of course, to consider. Number 1, connect key jury instructions with testimony and exhibits. You must teach the jury why what the court just told them in terms of what the law is mandates a verdict in your client's favor. The only way to do that is to show the interconnection between those instructions and the evidence and the testimony they've just listened to. Number 2, use the verdict form. Actually put the verdict form on a screen and answer the questions for the jury based on the evidence you believe warrants those answers. Number 3, something I just said a moment ago, stress your own strengths before you emphasize your opponent's weaknesses. Number 4, did your opponent make any promises in opening statement that he didn't deliver on? Get a copy of his opening statement. Search through it. Anything he said he'd prove that he didn't, show the jury. I've even blown up the transcript of opening statement and asked, he said he was going to prove this. I guess he forgot. Very powerful in closing. And finally, and perhaps more importantly than anything, you must believe in the cause. You must show the jury that you're simply not saying things because the client paid you to, but because you truly believe it. If you believe it, they'll believe it. That's jury prep and jury presentation in 10 minutes. Thank you.